Let's get right into it. As your attorneys here at IP Boutique Law, and crucially, as former USPTO examiners, we always start our consultations by asking you one thing. Exactly where does your true competitive advantage live? Because, having sat on the other side of that desk actually examining these applications, we know firsthand that choosing the wrong type of patent leaves your actual advantage completely unprotected. So today, we're going to walk through the precise, practical differences between design and utility patents.
We'll be walking you through a highly organized, 5-step breakdown today. We're covering what each patent protects, the actual USPTO examination process, the real costs and timelines, strategic choices, and finally, how infringement works in practice. Section 1. What each protects. We really have to start by establishing the foundational split in patent law, which is the difference between a product's appearance and its function. Under 35 U.S.C. Section 171 of the Patent Code, that's the federal statute governing this, a design patent protects the non-functional ornamental appearance of an article. Think of its specific shape, configuration, or surface decoration. On the flip side, under Section 101, a utility patent covers the functional aspects, like the way a thing works or how it's actually made. The rule of thumb here is simple. If a product's appearance is dictated entirely by how it must work, you just can't protect it with a design patent. You also need to understand how we set the boundaries of your protection, which is done through claims, those numbered, written statements at the end of a patent document that legally define the exact scope of your invention's functional protection. Now, for a design patent, there's only one claim, and the protection relies strictly on the solid lines shown in your drawings. But for a utility patent, that protection attaches entirely to your written claims, not the drawings at all. Moving to Section 2, the USPTO exam process. Now we're going to bring you behind the desk to show you what actually happened when we examined applications inside the patent office. Having done this work ourselves, we know exactly what the examiner's job entails. A design examiner mainly performs a visual comparison, searching the prior art, which consists of all previously published inventions and public knowledge worldwide, just looking for existing designs that are substantially similar to yours. A utility examiner, however, has to conduct a deeply complex search of that same prior art to confirm that your written description actually enables someone else to make the invention and that your claims are functionally novel. Because we evaluate design patents visually and the scope of what you claim in a drawing is highly specific, the USPTO historically allows roughly 84% of these applications. That means about 7 out of 8 design applications get approved. It's simply because the boundaries of visual protection are extremely clear-cut and well-defined. It's a completely different story for utility applications. The rigorous requirements for proving functional novelty meant we issued a first office action rejection, which is just an initial standard denial of the application by the examiner roughly 90% of the time. But don't panic. This first rejection is simply the beginning of a legal negotiation between us and the examiner over the exact wording and scope of your claims. There is a critical procedural difference here, though. We can easily reopen the utility application using a request for continued examination, or RCE, which is a standard procedural tool that pays for another round of review and negotiation after a final rejection. But if a design patent gets finally rejected, you can't use an RCE. Instead, you have to appeal directly to the Patent Trial and Appeal Board, or PTAB, which is an administrative court within the USPTO, and frankly, that presents a much higher hurdle. Section 3. Real costs and timelines. Let's move directly to the business math, because the stark difference in examination complexity completely drives the cost gap you're about to see. Looking at the bare numbers using USPTO small entity rates, which apply to most independent inventors and small businesses, a design patent is significantly less expensive upfront. Total USPTO fees sit around $1,040, and attorney drafting fees typically run between $1,000 and $2,000, usually wrapping up in about 18 to 24 months. A utility patent, on the other hand, requires a highly complex written specification that demands $2,000 to $15,000 or more in attorney fees depending on technical complexity, and it often takes 30 to 36 months or even longer to reach allowance. We also have to warn you about the hidden back-end costs. A utility patent, which lasts 20 years from your filing date, is going to cost an additional $6,500 in mandatory maintenance fees, paid at 3.5, 7.5, and 11.5 years, just to keep the patent enforceable. A design patent? That lasts 15 years from the date it's granted, and it requires 0 maintenance payments after the initial issue fee. None at all. Let's look at Section 4, Strategic Choices.
Now that we have the costs established, we need to evaluate practical scenarios so we can determine the exact strategy for your specific product.
Identifying the right tool for the job is essential here. We advise filing a design patent when the appearance of your product is what actually drives purchase decisions. This applies heavily to consumer goods, fashion accessories, packaging, or even graphical user interfaces on software. It's also the correct move when you need fast, affordable protection, especially if competitors are likely to just copy your product's aesthetics to steal market share without bothering to copy any underlying technology.
Conversely, we recommend utility patents strictly when the function or process is your novel asset. You choose this path when you need broad protection that stops competitors regardless of what their competing product looks like. It's also the necessary route when your product has a long commercial life that justifies those steeper prosecution costs, or when you are building a robust technical portfolio specifically for licensing or acquisition down the road.
Sometimes, layering both patents is an effective strategy to trap competitors. For step 1, you have to ensure both the appearance and the function are independently novel. If they are, step 2 is filing a non-provisional utility application right alongside a design application. What we will not do is advise filing a design patent on a purely functional item simply because it's cheaper. Doing that provides easily circumventable protection when what you actually needed was broader utility protection.
Finally, Section 5, how infringement works. We have to look at how this protection actually holds up in court when a competitor inevitably tries to copy you. For design patents, we apply the legal standard from the Federal Circuit case, Egyptian Goddess. The test asks whether an ordinary observer, meaning a typical purchaser paying normal attention, would find the accused product and your patented design substantially similar. This is strictly a visual, side-by-side comparison of your patent drawings against the competitor's physical product. If the competitor creates a product with a noticeably different appearance, they generally avoid infringement, even if the products serve the exact same function. We contrast that visual test with utility infringement, which is governed by the rigorous written claims test. To prove infringement here, every single element of at least one of your written claims must be physically present in the competitor's product or process. Appearance is completely irrelevant. If your claim lists parts A, B, and C, and the competitor uses A, B, and C to perform the same function, they infringe your patent, no matter how different their product looks on the outside. That right there is exactly why utility patents are substantially harder to design around.
So we close our consultation today by asking you to look closely at your invention. Does your actual competitive advantage lie in how your product looks or in how it works? Identifying this core advantage definitively is the only way to secure the exact protection your business requires. Take a step back, evaluate your product objectively, and decide, where does your true value lie?